Our next speaker is Chip Houssiere, and I've known Chip many years. I've referred cases to him on medical malpractice. He has on-staff doctors. He is tireless in the way that he approaches these difficult cases, as you know. And he's been a friend of HTLA, TTLA, Harris County Democratic Lawyers Association, and has given his time, energy, and dedication to come to this seminar and teach us what's going on in the world of medical malpractice. Chip Houssiere.
Thank you. Thank you very much, especially for everybody here so late. And Bob, thank you for putting this together. It's a tremendous seminar. The people that I've tried cases with and against are here speaking, and I tell you, they're great lawyers, and you've learned a lot. I appreciate people like yourself running for judge. Everything starts there. Those cases that Tim was talking about that he tried, it starts in the trial court. We need the judges to find for us. We need you there, and we need to support them. And maybe then we'll turn this around. My firm represents families against the healthcare industry. I'm a scientific lawyer. That's what we claim we are, and that's what we do, or we try to do. So therefore, we work on medical negligence cases. I was trying to find some interesting photographs to put in my talk, and this is the picture of an inexperienced trial lawyer that is thinking, oh my God, I've got to write a report in my med-mal case. Or maybe it's the emergency room physician who's practicing the fine art of obfuscation when something goes wrong in the emergency room. It is not unusual in the history of the world that people attack science and scientists because of what they say. 600 years ago, Galileo, the fellow that claimed that the earth rotated around the sun, was branded as a heretic. Some of his people were burned at the stake and killed. And in a historic argument about why ice floats on water, there was a serious consideration as to whether he was going to lose his life because it was not approved of by the papal judges of the time. So when we deal with medical malpractice cases and we say, well, gee, you know, life is tough, our cases are getting dismissed, at least we're not burned at the stake. What you have to do in a medical negligence case is you must prepare a report that is an objective, good faith effort to provide two pieces of information. One, inform the defendant of the conduct that's in question, and to provide the basis for the court to determine that that statement is accurate. Years ago, I was speaking in San Antonio, and there was a judge there on the Supreme Court who won't be mentioned, but by the way, our governor has appointed or suggested that Nathan Heck be the Chief Justice of our Supreme Court. And I was speaking there, and I said, well, you know, I just don't understand why if a person is injured over $500,000, why we should limit that recovery in the state of Texas as a frivolous lawsuit. How can you be frivolous if it's over $500,000? And Heck, this gentleman turns up and it turns to me and he says, well, you see, there you are. There's a clever plaintiff's lawyer lobbying the judges right in front of us. And that wasn't what I was trying to do. I was just complaining about the act. And that was in 1977 act. That act has been changed in tort reform in 2003. Now, anything over $250,000 is a frivolous lawsuit. I mean, how can it be? Really what it is the Fair Insurance Improvement Act of 1977 and an Insurance Act of 2003, so that the insurance companies won't have to pay out claims and can collect more premiums from the physicians. So why do we have it? Why do we have to have a report? Before we even start depositions or litigation in this particular type of cause of action in the state of Texas? Well, ostensibly it's so that the trial court, the trial judges, look at the case and determine whether it has merit to keep those frivolous lawsuits out. Now, I suspect that nobody in this room is going to bring a frivolous lawsuit because it's expensive to bring a lawsuit. None of the cases that are brought are frivolous. None of the people that come to my office have frivolous claims any more than the lady that came in a couple of days ago whose baby is totally brain dead because the physician failed to read the ultrasound correctly and determine that her placenta was growing too low, and eventually she nearly bled to death before the baby was born. That's not a frivolous lawsuit, but limited to $250,000 for pain, suffering, and mental anguish. What do you have to put in your report? You have to talk about standards of care. Now, how many of your doctors have gone out, have been polled, and said, gee, how do you do a cholecystectomy, a gallbladder procedure? Let me find out from you, do you do it this way or do you do it this way? And let's do a statistical analysis, and we'll have a standard deviation, and we'll have a mean, and we'll have a curve, and we'll say this is the standard of care. There's no such thing as the standard of care. It is a creation of the people who promoted this act that comes up with the standard of care. Yes, there is an outfit called ACOG, American College of Obstetrics and Gynecology, that has a standard that they publish periodically. But that's a defensive standard. That's published so that doctors don't have to live up to anything more than that. That is not a standard of care. If you ask your own doctor, what do you do? Well, I do what a reasonable physician would do under the circumstances, not some arbitrary written standard. They won't even accept, in most cases, that a journal article is, in fact, a learned treatise that they need to listen to. So there are no standards of care in medicine, period. There aren't any. But because of this fiction, we have to put it in our reports. We have to get our experts to do it. We have to pay them to say what the standards of care are. We have to show that those standards are violated. We have to say also not just what the standard was and that it was violated, but what they should have done and what would have occurred if, in fact, the appropriate care had been given. I was listening to talks here today about proximate cause and foreseeability. Somewhere along the line, I decided it was easier for me to take a look at special issues or questions that go to a jury before I start the case. And I read them, and I think about them, and I start developing my case from that, because if I don't get a yes in those blanks, what difference does it make? So I think about that from the beginning, and somewhere along the line it just occurred to me that I should ask the doctor, well, isn't it reasonably foreseeable this event or some similar event could have occurred? Well, that came out of the pattern jury charge. I didn't make those words up. Nobody understands them. The doctor doesn't understand them. If you catch them early enough, the lawyer hasn't educated them to stay away from those, and you're going to get some answers you can't believe. Well, sure, a reasonable doctor could foresee that that would occur. Takes care of your proximate cause issue, makes the defense lawyer have heartburn. It's wonderful. Ask that question, isn't it foreseeable that this event or some similar event could have occurred in your depositions? So, when we're faced with one of these cases, and we create our best effort at doing these reports, and when I started practicing 35 years ago, the reports were like 1 or 2 pages long. Today, they're 30 pages long. So we submit these to the court for their consideration. Non-scientist judges to read through this diatribe, and most of them are sick of it, frankly. We submit this to them, and then they have to look at it, and they have to look at only what's written there. We don't have to talk about what inferences are drawn. We don't have to bring in other evidence. The court can only look at what's written in our reports. Don't be confused by that. In our report, we have to have the basis of the statements, which includes proving your doctor is qualified, which includes how did he learn about it, which includes what the standards are, which includes the pathophysiology from the date of the injury all the way down the line through the continuous sequence of events that produces the injury or damages at the end. You have to put all that in your report, and you have to have a CV to go along with it. If you don't, you've got a problem. Who can write these reports? Only medical doctors or healthcare providers if you're talking about something that a hospital did incorrectly. Only doctors and healthcare providers. Who can talk about causation? Only medical doctors, except for dentists and podiatrists. Only medical doctors. So, bless you. But the defense to these cases is just as Tim was saying. It's causation. So we can probably determine what the violation of the standard of care was. You gave the wrong drug. You didn't take them off the drug soon enough. You did the wrong procedure. You cut the wrong thing. You operated outside the field. You didn't diagnose the condition. That's the wrong. It's easier to figure out what the standard of care was, but how are you going to prove that their failure caused the injury? Because after all, they're in the hospital for a reason. They're sick anyway. How are you going to differentiate between the two? That's your challenge in these cases. And your expert can only be a medical doctor, not a Texas doctor necessarily, but should be. But you have to have a medical doctor say it. How does the court determine whether the doctor is qualified? Well, one of the things he looks at is he board certified in the field, or is she board certified in the field? Do they have substantial training in the field? I put all of this in my reports. Went to this hospital, went to this medical school, he learned this, he learned that, he taught courses to nurses, and nurses taught courses to him. He learned all this information, and that's how he knows that he can testify about what the standards of care are, what a reasonable physician would do. Same thing about causation. Now, let's take an alpurinol case. That's a drug you give for gout. Gout's is hyperuricemia, elevated urine in the bloodstream. It's not being cleared out for probably kidney failure, and so you give this medicine to somebody who has gout. Well, you don't want to give it to them if they don't have symptoms of pain in their joints, because gout is just crystalline uric acid getting into the joints causing pain. If you give that particular medicine to a patient what will happen to them is their skin will slough off and they will die of a condition called Stevens-Johnson syndrome, which is like being burned to death, except slowly with medicine. Now, you're faced with that case. It sounds horrible that the doctor gave them the medicine when they didn't have gout symptoms. Maybe they gave too much of it. Maybe they didn't take them off of it when they had a rash. That's the standard of care. That was what was done wrong. You get a nephrologist to test about that, a kidney doctor. But what about the fact that they get Stevens-Johnson syndrome? Can that kidney doctor testify about, well, you know, if he'd just been taken this medicine off, even though he had the rash, we could have treated him in this fashion and he would survive. Kidney doctors don't treat that. That's treated like a burn patient by a plastic surgeon. So you have to bring another doctor to testify about that. If you don't have the appropriate physicians, if you don't have the appropriate statements within your report, you've got a serious problem. Vicarious liability. Let's say that you file a claim against a nurse. Do you have to have a report against the hospital? No, you don't. Unless your claim is just against the hospital. If your claim is against the hospital for failing to have policies and procedures, for instance, you have to have an expert in that regard. Why is that important? That's important because if you don't have a report on a particular defendant, you're going to have a problem because you have to have a report on every defendant. But if you sue a nurse and you get a report that the nurse did wrong, then the hospital's still held. When do you have to file this? If you don't file it, the bomb is ticking. It's 120 days from the date that you file your lawsuit as of August 31, 2013. As of 2005, it was from the lawsuit being filed. As of 2003, it was when the claim was filed. And you probably don't have any cases back in the 4590I era where you had to file it within 180 days. Today, you have to file this report within 120 days of your lawsuit being filed. But on September the 1st of this year, the act was amended. And you have to file your report within 120 days, starting with the day after you file the defendant's answer. Why is that important? Because the defendant was playing run out the clock. They wouldn't answer your case. They wouldn't give you records. And if you didn't have a report on file, and you can't get a report on file without the records, right? Your case is going to get dismissed. So this actually, I would say the pendulum is slightly swinging in our favor in medical malpractice. This is very beneficial for the plaintiff's lawyers. Said very simply, you have 120 days from the date that the defendant files their answer. I recommend, by the way, filing your report, your CV, your discovery, and your petition at the same time. You don't have to worry about then filing it in a timely manner. It's served on everybody right then. It's served after the doctor's been made a defendant or the hospital or whatever, because you have filed your lawsuit. So you are filing it within 120 days of the answer and after the defendant becomes a party. If you don't do that, defense counsel is going to look at the case and say, hey, you know, they must not be too excited about this case if they don't have an expert report, and wait the 120 days. So my recommendation is you do that. My recommendation is that you get 2 reports. One report is this Chapter 74 report, which informs the physician about what they did wrong and gives the basis for it, right? We talked about that. The other report, and that's not admissible for any purpose, the other report that I suggest you get is a very short report that talks about liability, causation, and damages, like we normally would to normal people, not with all this standard of care junk. Just a regular small report in affidavit form, because you're going to be faced with a no evidence motion for summary judgment. Then you got to go back, find your doctor, get a new report, spend the money. You'll have this in your back pocket, and you won't have to deal with it. It's cheaper to do it that way, in my opinion. So, what happens if you don't file it? Or what happens if it's not sufficient? You'll get our gentleman here objecting to the report as it being insufficient. Now, if you don't file an objection to the report the plaintiff filed, then it's waived. But you must file it within 21 days of the time you're served with the report, as of August 31st of this year. But as of September 1st of this year, the defendant must file an objection to your report 21 days after the latter of the date the report is served, which is, I suggest, is the date of the initial service with the petition, or the date the defendant has filed an answer. So that will be a determination during the litigation as to when the report will be attacked by the defendant. I would also recommend that you file a motion for sanctions. Once you've spent $5,000 to $10,000 on a report, 35 pages long, which is what they usually cost, they're going to be good. And you're not going to take a frivolous lawsuit. You're not going to spend that money on that case. What's frivolous is the objection. Attack them on that. I've done that before. I was almost successful in getting a district court to sanction them, to the point where the hospital said, look, man, I didn't object to this report. Don't blame me. So I really, really strongly suggest that if you're doing this kind of law and you file a report and somebody objects to it, you ask for sanctions. As I said before, the report is not admissible for any reason in litigation. Though you can't bring it up in evidence, you can't show it to the expert when he's deposed, if he's your expert ultimately. You can't use it for any purpose whatsoever. Don't waive that by producing it in discovery. So what happens if you fail to file a report? Well, you're going to be sanctioned. And the least I've heard of is $35,000. Okay? So you want to file your report. But again, nobody's going to bring one of these cases and file a report unless they think they've done the right thing, because they're not going to spend the money on it, their time. So how do you get into this situation? How do lawyers get into this problem? Well, they may inadvertently leave a major issue out of the report, like standard of care or causation, or leave the CV off. Don't serve the CV. When your report is objected to, ask the court also for a 30-day extension. You get one 30-day extension from the court, and they usually give it to you if you've made any effort whatsoever to file a report and it has all of the elements of it. So if you do that, you should stay out of trouble. This act defines healthcare liability claims, Chapter 74, defines healthcare liability claims as medical care, health care, that seems reasonable, right? Or safety. So if you follow David Ball and the reptile brain theory is that we're all concerned only about safety, that's really a neat section of the act. So we can sue a doctor or a hospital for not providing safety or professional or administrative services directly related to health care. Now, does safety mean health care? According to our courts, it does. Our friends in the Supreme Court talked about something called the Oxford comma or serial comma. Y'all learned all that, I'm sure, in law school. And they stated that if there had been a comma by safety here, then safety would be separate and apart from health care. But since there was no comma here, safety is health care. Now, all the cases that have interpreted this deal with health care and safety. And what I found humorous, the court said, in discussing the Oxford or serial comma, there are people who embrace the Oxford comma and people who don't. And I'll just say this, never get between these people when drink has been taken. So it's reached the absurd level in these cases. So here's another area that you get in trouble in. If it looks like, smells like, tastes like a healthcare liability claim, it is. Here's an example. A person goes to a psychiatric hospital. The staff at the hospital is taking care of the patient. The person that's under psychiatric care blows up, attacks the staff member, beats them up horribly. Staff member is a contract nurse, doesn't really work directly for the institution. And the nurse sues the institution for failing to provide adequate security for the nurse against these dangerous psychiatric patients. Is that a healthcare liability claim? Our Supreme Court said it was. Plaintiff's lawyer failed to write a report. The case was remanded to the trial court. Trial court was asked to dismiss the case with prejudice and convene a hearing to fine the lawyer for bringing the case and attorney's fees and costs. That happened August 23rd, 2013. Is it health care if a doctor's at home at night and he's called and said, come down to the emergency room quick, we're going to deliver a baby, you got to get down here. He jumps in his Corvette and he rushes down and he runs over somebody and kills them. Is that health care? I don't know. You might want to consider an expert report in a case like that. What about weird theories like battery? Battery you have to have a report for. What about a blood bank? Blood bank is not a health care liability claim if they give you the wrong blood. Here's an interesting case, similar to the one that we're talking about, the 1983 case where the officers were molesting prisoners. This doctor, board-certified physician, has this young teenage girl, gets her in his office to do a physical examination of her. He's going to check her heart rate. So he has her disrobed from the waist up. And then he begins to fondle her for about 30 minutes. And the family was horrified. She was horrified. They sued the doctor. And the case went up on appeal. Is that health care? The court said, we're not going to consider the report filed by the plaintiff's lawyer because we don't think it's health care. But we're going to remand it to the state court to make a determination of whether this is health care or not. Because if it's not health care, you don't need a report. And they gave a test for these kind of cases. And it says three prongs to it. One, is the plaintiff complaining of the health care or that is the alleged offensive conduct? She wasn't complaining of health care. She was complaining that this wasn't health care. Two, the contact is not pursuant to consent. She didn't consent to that. She may have consented to an examination, but not to that. And three, the relationship was the setting was the only reason that it had anything to do with health care. It just happened to be in his office. If it's just that, you've probably satisfied those three prongs and you don't need a report. But frankly, even though I've been doing this a while, I can't tell you whether you need a report in a case like that or not. Be careful if you take on a medical malpractice case when there's anybody involved in healthcare doing anything that could be a defendant in the case. If the court finds that the report is deficient, they will grant a 30-day extension, and you can then go back, try to find your expert, try to get it corrected, try to get another expert, and submit an additional report. The court shall grant the motion for extension unless there's something very unusual or you leave a complete part out of the report, as I said earlier. Can you do discovery in this case and learn a little bit about the case maybe before you file your report? No. Can't do any discovery except for three things. You can send out written discovery, you can take depositions by written question, but only two for all parties. So if you've got one of these cases, you're going to have to base it upon the records. And believe it or not, the records plus the plaintiff's petition. Plaintiff's petition can be considered. Don't just give your expert your petition, but you can give your expert your petition and he can base it upon what's written in there as well. Interlocutory appeal. During the pendency of the argument about whether the report is adequate or not, the losing party in that hearing can file an interlocutory appeal. Can you do discovery during the interlocutory appeal? No more than I just discussed with you. And the appellate issue is an abuse of discretion standard regarding the sufficiency of the report. Did the judge, looking at the four corners of the report, abuse their discretion, and was there only one way to look at this and the way he found it? If there was another, then he may have abused his discretion. If on appeal, however, they're trying to interpret the statute, then the statute itself is like a trial de novo, and it's not an abuse of discretion standard, and that's a problem for us on appeals of these cases. By the way, I was told that there are more appeals in the state of Texas on this issue of an expert report than all other appeals combined. So it's problematic. As Galileo learned and everybody else did, it's really the fact that ice is less dense than water, that ice floats on water because the crystalline structure is lighter than regular water. And I leave you this last thought, which you can take to the reception at the end, that as our noted philosopher Mark Twain said, whiskey is for drinking, water is for fighting over. Thank you.
I want to thank Chip for putting together that excellent presentation.